government is pleased to introduce the Anti-Discrimination Amendment Religious Vilification Bill 2023. The bill implements the government's election commitment to make religious vilification unlawful by introducing a civil prohibition aligning with the existing vilification provisions in the Anti-Discrimination Act. It is important to ensure that people are free from vilification on the basis of their religious belief, affiliation or activity. This bill will fill a gap in the existing vilification protections in the Act by extending them to religion and will provide an important protection for people of faith. The government recognises that the Act as a whole is out of date and in need of an overhaul, and has committed to tasking the New South Wales Law Reform Commission to conduct a comprehensive review. The review is imminent. Under the Act, it is currently unlawful to, by a public act, incite hatred towards, serious contempt for, or severe ridicule of a person or group of persons on 4 grounds. These grounds are race, homosexuality, transgender status, and HIV/AIDS status. The bill will extend the same form of protection from vilification that already exists in the Act in respect of these grounds to vilification on the basis of religion. The Act's provisions on racial vilification currently apply to vilification on the basis of ethno-religious origin because race is defined to include this term. However, this concept has been narrowly interpreted. The amendment in the bill means that religious vilification complaints can be considered through their own separate ground, without needing to inquire into whether an ethno-religious origin can be established. The civil prohibition in the bill will complement the existing related criminal offence in the Crimes Act 1900, Section 93Z, which applies to religion and prohibits publicly threatening or inciting violence towards a person or group on grounds including religious belief or affiliation. It is important that the prohibition, as a restriction on public expression, strikes the right balance between protection from vilification and ensuring appropriate freedom of expression and religion. The bill does this by including appropriate exceptions that make conduct that may otherwise amount to vilification lawful, particularly for good faith discussions in the public interest. The provisions in the bill are not intended to prevent people from making statements about the truth of their own religious beliefs, or to prevent people making statements that are critical of a religion or religion in general. The provisions do not protect religion or religious beliefs themselves, and they are not intended to be used to silence criticism or debate. Instead, they give appropriate remedies to people who are subject to incitements of hatred, serious contempt, or severe ridicule on the basis of religion. Complaints of religious vilification will be able to be made to the President of the Anti-Discrimination Board, who will encourage mediation if possible, and can otherwise refer a complaint to the New South Wales Civil and Administrative Tribunal. The tribunal can then order a range of remedies, including damages or an apology or retraction if it finds a complaint is substantiated. The government has consulted on the bill with a range of stakeholders, including religious organisations, legal stakeholders, and community and advocacy organisations. Most stakeholders were supportive of the bill, particularly religious and faith organisations who expressed strong support for a prohibition on religious vilification. I now turn to the detail of the bill in relation to its amendments to the Anti-Discrimination Act 1977. Schedule 1 of the bill inserts a new Part 4BA into the Act. Schedule 1 of the bill inserts the new Section 49ZE, which makes it unlawful for a person by a public act to incite hatred towards, serious contempt for, or severe ridicule of a person or group of persons on the grounds that they have or do not have a religious belief or affiliation, or engage or do not engage in religious activity. Schedule 1 of the bill also inserts the new section 49ZD, which defines a public act consistently with the existing vilification provisions. A public act includes any form of communication to the public, including speaking, writing, printing, broadcasting or screening, as well as non-verbal conduct observable by the public. The definition also includes the distribution or dissemination of matter to the public with knowledge that it promotes or expresses hatred towards, serious contempt for, or severe ridicule of a person or group of persons on the grounds of religious belief or affiliation or religious activity. The new ground for vilification covered by the bill is holding or not holding religious belief or religious affiliation or engaging in religious activity. It is important that people are protected from vilification because of their beliefs, but also because of their connections with faiths or religious organisations, as well as the practices or activities that are related to religion. It is also important that people are protected from vilification because they do not hold religious beliefs or affiliations or engage in religious activities. This is because not holding a religious belief is itself a belief about religious matters, which should be protected from vilification. The new protected ground in the amendments has been drafted consistently with civil protections against religious vilification in other states and territories. In Victoria, vilification on the grounds of religious belief activity, which includes holding or not holding a religious belief or engaging in or not engaging in a religious activity, is unlawful. In the ACT and Tasmania, vilification on the basis of religious belief, affiliation and activity are unlawful. The new section 49ZE(2) inserted by Schedule 1 of the bill contains 3 exceptions that prevent conduct that would otherwise amount to religious vilification from being unlawful. The exceptions apply to A, fair report of a public act, B, communication or the distribution or dissemination of any matter on an occasion that would be subject to a defence of absolute privilege under defamation law in proceedings for defamation, and C, a public act done reasonably and in good faith for academic, artistic, scientific, research or religious discussion or instruction purposes, or for other purposes in the public interest, including discussion or debate about and expositions of an act or matter. This final exception at new section 49E(2)(c) ensures that legitimate public discussion in the public interest is not made unlawful by the provisions. It also ensures that people can carry on their own religious practices and expression. To use the exception at the new section 49ZE(2)(c), the public discussion or debate must be done reasonably and in good faith. The concept of reasonableness in this context has been discussed by the courts. The Chief Justice of the New South Wales Court of Appeal, Chief Justice Bathurst, stated in Sunol versus Collier, number 2, that for the public act to be reasonable, it must bear a rational relationship to the protected activity and not be disproportionate to what is necessary to carry it out. In addition, Sunol versus Collier held that the concept of good faith does not require an objective assessment of intention, but instead that the public act must be engaged in bona fide and for the protected purpose. The exception at the new section 49ZE(2)(c) is important because the prohibition on religious vilification in the bill is about protecting against the incitement of hatred towards a person or group of persons. It is not intended to prohibit criticism of religion or religions themselves, or to prevent statements of religious faith. As the Victorian Court of Appeal has stated in relation to similar Victorian provisions in the Catch the Fire Ministries case, vilification aims to strike a balance between protecting freedom of speech and protecting people from vilification on the grounds of their religious belief. It would be inconsistent with this aim to interpret the legislation so as to make it impossible for people to proselytise for their own faith or to criticise the religious belief of others. The Act includes a comprehensive set of complaints provisions that will apply to the new vilification ground in the bill. A person will be able to lodge a complaint with the President of the Anti-Discrimination Board, who will attempt to encourage conciliation, but who may also refer the complaint to the Civil and Administrative Tribunal. If the tribunal finds a complaint substantiated, it may order a range of remedies depending on the particular circumstances of the matter, including damages or orders requiring an apology, retraction, or to not engage in further unlawful activity. Robust debate and freedom of expression are critical to a healthy democracy. However, it is important that there are reasonable limits on expression to prevent people from being the target of hatred. This bill is intended to ensure that people in New South Wales can maintain their religious beliefs and practice their religion without fear of vilification, and to provide a remedy for religious vilification if it occurs. Madam Deputy President, I commend the bill to the House.